So we have an important development in a lawsuit which aims to remove state bans on the purchase and possession of suppressors. So let's break down what just happened. Now, before we jump into this video, I want to thank one of the main supporters of this channel, which is First Form. You guys know that First Form is an amazing company. They have great supplements. I really enjoy their protein powder and their pre-workout. And also one of the really cool things about them is their culture is unmatched. They, work hard in everything that they do, and it bleeds into everything. And they partner with people that, have the same ethos, including being pro-freedom, pro-America, and they also support the Second Amendment and what we talk about here on the channel. So if you guys want to support me and support an amazing company that believes in the Second Amendment, check them out using the links down below. That will be in the detail section and also in the pinned comment. And if you order something $100 or more, you can get free shipping, and also they have a money-back guarantee. As I mentioned in the intro, in this video, we're going to be discussing a new suppressor decision, which was issued in 2 lawsuits which aim to remove a state ban on the purchase and possession of suppressors. The cases that we're going to be talking about in this video are Morse versus Raoul, and then also Anderson versus Raoul. These lawsuits are very important because although 42 states allow the ownership of suppressors, there are 9 jurisdictions within the United States which restrict the access to those items. These lawsuits could be the first in the nation which find that a state's outright ban on NFA items like suppressors is in fact unconstitutional and that it violates the Second Amendment. However, the district court in this case issued a ruling in favor of the state of Illinois, and it granted the state's motion for judgment on the pleadings. The court found that there is no history or tradition to show that suppressors are protected arms under the Second Amendment. Therefore, the court ruled that the plaintiffs failed to state a plausible Second Amendment claim, and therefore they struck down their challenge. However, this case is far from over, and now it has been appealed to the 7th Circuit for a reversal of that ruling. Now, one of the interesting things about this ruling, it's kind of the first analysis that I've seen that's kind of came to this conclusion in this specific way, and it's a very concerning analysis that was actually developed by this district court. This suppressor lawsuit here aims to finally make a state explain how their outright ban on the purchase and possession of suppressors is consistent with Heller and now Bruin, and how it's consistent with this nation's history and tradition. However, in this recent ruling by the lower court, they kind of seem to flip that burden and apply it to the plaintiffs themselves instead of the state that is banning these items. The Illinois federal court ruled that the plaintiffs did not show that there was a history or tradition to support their claim that suppressors are afforded to protections. In this lawsuit, the plaintiffs argue that the Second Amendment reference to arms does not apply only to those arms that were in existence in the 18th century and only, during the founding. They stated that just as the First Amendment protects modern forms of communication, the Fourth Amendment applies to modern forms of search. The Second Amendment extends prima facie to all instruments that constitute bearable arms, even those that were not in existence at the time of the founding. Thus, even though the Second Amendment's definition of arms is fixed according to the historical understanding, the general definition covers modern instruments that facilitate armed self-defense. So that argument that suppressors are not protected since they did not exist during the founding is irrelevant, and that's essentially what the plaintiffs argued here in this case. However, the district court found the exact opposite. The court ruled that while modern innovations can fall under the Second Amendment if they are modern versions of historically recognized arms, they state that there is no historical tradition or precedent showing that devices designed to reduce the sound of guns were ever considered arms at the time of the founding. In essence, the court here found that the modern item can only be protected if there is a historical analog that they can draw then a parallel to. Now, that is not something that the Supreme Court stated in Bruin, but the lower court here is creating its own test in saying that an item is only a protected arm for the purposes of the Second Amendment is something equivalent actually existed during the founding. The district court found that since silencers are accessories rather than weapons themselves, and plaintiffs could not point to any historical analog or evidence that silencers were part of the original understanding of arms for the Second Amendment, they could not actually state a plausible claim under the Second Amendment, and therefore the court there issued the judgment on the pleadings in favor of the state of Illinois. The court stated that the difficulty with the plaintiff's contention that silencers are arms is that unlike AR-15s or AK-47 rifles, for example, plaintiffs have not shown that silencers are modern forms of weapons known to be in use or available in the ratification period. The plaintiff's complaints and the record are devoid of any reference to a time in our history of our country where any early generation device, accessory, or attachment was broadly employed to reduce the report of a firearm. Put another way, they state, plaintiffs offer nothing to suggest there is a fixed historical understanding that devices which serve only to enhance operation of a firearm by reducing its reports are arms themselves. At the same time, they state some attachments are so integral to the effective operation of a firearm that they might be logically included within the historical fixed understanding of an arm. For example, the judge states there have been significant technological advances in firearms aiming technology, from periods where no sighting device was used, progressing to traditional iron sights, and then evolving into modern era and more sophisticated optical sights like red dots, and then also, LPVOs and things like that. They state that the same can be said about modern magazines that now allow the ammunition to be fed into battery much more quickly and effectively than each cartridge could be inserted by hand prior. The judge concludes by stating that nothing in the pleadings demonstrates the existence of a historical precursor to a silencer that would show prior use or understanding by those living near the time of the Second Amendment's ratification. As a result, plaintiffs have failed to plead a plausible claim, and defendants are entitled to judgment as a matter of law. So this is a very interesting ruling by the court here, and kind of one of the first full decisions of this type that I've seen. The judge took the Bruin analysis in the ruling there to say that essentially any item is only protected, and it's only protected as an arm under the Second Amendment if you can show that there is a historical precursor of that item that existed during the ratification period or maybe close to that. If the modern firearm or item does not have a historical precursor dating back to something like 1791, it may not be protected. The only way to kind of carve that out is maybe to show that the firearm technology has developed from a point of the item that maybe existed historically to something now where it's so necessary for the function of the firearm that it's essentially a proxy of something, and therefore it kind of gets this proxy protection under the Second Amendment. This line of analysis is very concerning to me and potentially opens the door to a lot of other items losing to a protections if you can't show that there is maybe a historical precursor or something that existed at the time of the founding. However, this case is far from over, it's not finished, and that analysis is now going to be tested at the appeals court level because the plaintiffs here now have sought an appeal to the Seventh Circuit. So this is now moving up the chain, and it's going to move up to the Seventh Circuit Court of Appeals. Now, the Seventh Circuit has not been super great when it comes to 2A issues, but this is one of those very concerning rulings that as it moves up to the higher court levels and maybe even potentially to the Supreme Court, this is something that the Supreme Court would be very interested in because, again, it's an atypical type of ruling where they're saying an item is only a protected arm if a similar item existed during the period of the Second Amendment's ratification. That is not something that Bruin has said. That is not something the Supreme Court has outlined to this point. They have not said that that is actually the true statement. And so this analysis is going to get tested at the higher court levels, and we're going to see, how does the Seventh Circuit rule on this, and ultimately maybe how does the Supreme Court come out on this issue. So this is something that we're going to be watching closely, and this is an important lawsuit for a lot of other states that have similar NFA item bans like California, New York, New Jersey, and others, where they ban things like suppressors and SBRs. So as we get more information, as it develops more, I will let you guys know. If you like this video and you would like to support the channel, one of the best ways to do that, of course, is to subscribe to the channel. Also, you can check out my website, armscholar.com. Over there, we have a lot for you guys, deals, coupons, all of that, free legal guide if you guys are interested in that, and just a lot that you guys can check out by going to my website. But as always, thank you guys so much for all of your support. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.